distinguished guests, participants, ladies and gentlemen, a very good afternoon to you all. It's been great honor for me, Sekar Chandra, to be a master of ceremony for this occasion today. Okay, before we start our agenda today, we would like to express our sincere gratitude to the Dean of Faculty of Law, Mrs. Dr. Yesari Murti Widyastuti SHM Hum, and the all deputy deans, all lecturers of Faculty of Law Universitas Atmajaya Yogyakarta, Excellency speaker from St. Louis University, Philippines, Mr. Eti Anthony Luis Avila, and all academic community, Faculty of Law Universitas Atmajaya Yogyakarta. Welcome to the 11th virtual lecturer series with the topic International Law and Human Rights. As a start of our opening ceremony, we will sing the national anthem of the Republic of Indonesia that will be led by Gita Widya Choir.
Indonesia, tanah airku, tanah tumpah darahku. Di sanalah aku berdiri, jadi pandu hidupku. Indonesia, kebangsaanku, bangsa dan tanah airku. Marilah kita bersatu, Indonesia bersatu. Hiduplah tanahku, hiduplah negeriku, bangsaku, rakyatku semuanya. Bangunlah jiwanya, bangunlah badannya untuk Indonesia Raya. Indonesia Raya, merdeka, merdeka, tanahku, negeriku yang ku cinta. Indonesia Raya, merdeka, merdeka, hiduplah Indonesia Raya. Indonesia Raya, merdeka, merdeka, tanahku, negeriku yang ku cinta. Indonesia Raya, merdeka, merdeka, hiduplah Indonesia Raya.
Gita Widya Law Choir consisting by Law School of Faculty of Law Universitas Atmajaya Yogyakarta. Excellencies, upon here, ladies and gentlemen, now we are going to listen to the opening remark delivered by the Dean of Faculty of Law Universitas Atmajaya Yogyakarta. Please be invited, Mrs. Dr. Yesari Murti Widyastuti SHM Hum.
Okay, thank you, Ibu Sekar, as a master ceremony today. Good afternoon. The Honorable of Professor Ati Anton Luis Avita, which is I respect also the Vice Deans, lecturers, and of course the student of Atmajaya Yogyakarta University. Welcome to the Law School of Atmajaya Yogyakarta, which is located in the heart of civilization, because Yogyakarta has a philosophy that emphasizes respect for human dignity. Thank you for the opportunity given to me to welcome Prof. Ati and all of you in the 11 virtual lectures series with the theme International Law and Human Rights. Prof. Ati, when I heard the news that Prof. Ati was pleased to be at Atmajaya virtually, my memory of SLU in Baguio City as a Pine City was back. I visited SLU for a study visit in 2005 and I stayed at the palace for 1 month. It's very nice. Baguio City is a city designed by taking into account the balance of nature. Make the city cool and also comfortable to study. I've tasted the culinary, as I mentioned before, boiled egg that have grown embryos in them. So spectacular for me. Well, I think the student and also the lecturer can wait to listen, to Prof. Ati lecture today. So finally, enjoy the lecture from Prof. Ati. I hope there will be discussion that are useful for respecting, protecting, and promoting human rights. Thank you very much, Prof. Ati, and have a nice lecture today. Thank you.
Okay, thank you. Thank you for Mrs. Dr. Ria Sarimurti Widyastuti SHM Home for the opening remarks. Well, Excellencies, distinguished guests, and all participants, now we will take a photo session. To the Dean, to the Deputy Deans, and all lecturers and all participants, please to open your camera and we will take photo. I will count in 1, 2, 3. So we will take the photo in the third count. Okay, 1, 2. Okay, 1. Okay. Please hold for a minute. The host still prepare for the photo session. Okay. Let me take the photo. 1, 2, 3. Okay. Please to spotlight the speaker, maybe. Okay. Please spotlight for the dean and the speaker and the moderator. All right, we will take the photo. 1, 2, and 3. Okay, thank you. Now, I will give the time for the moderator. The moderator today is Mr. Endro Susilo as lecturer of International Law of Faculty of Law Universitas Atmajaya Yogyakarta. So now I leave the time to the moderator. Mr. Endro Susilo, please.
Indra, please open your mic,
your microphone.
Indra, please open your mic first. Yeah.
Thank you, Ibu Sekar Chandra, and good afternoon, Professor Avila, and all audience who join this discussions, even though we said, as a series of lecture that will be given by Professor Avila. It's good to be here with me because, well, this is a good opportunity for our students and also for our colleagues, because we will have a discussion on international law and human rights. Well, it's very wide, but we all understand that human rights now is not only categorized as a domestic issue. It's been a global issue. And we also know that the UN also has played a very important role in defining and advancing human rights. So there are a lot of regulations, declarations, and this is very interesting. In one point, we have that it has been stressed in international community, but we also still, see that there are some violation of human rights, right? So that's the point. That's, I believe, the topic will be, delivered by Professor Avila, and I believe that the audience also learn because most of them are students who take human rights in a subject in their class, and I believe that the discussion will be very interesting for the audience. And yes, time is yours, Professor Avila, to present your ideas, your insights to all audience here, please.
All right. Thank you so much for introducing me, Professor Endro Susilo. I would like to, before I would start my lecture, I would like to thank again Dean Mrs. Dr. Sarimuthi for this opportunity of speaking before the Faculty of Law of Atmajaya University of Jakarta. And I would also like to thank the participation of everyone here, including the vice deans, lecturers, and our master of ceremony for today, Ms. Sekar Chandra. So allow me to share my screen first. So for today, I'm going to limit myself within the topics of the International Bill of Rights. International human rights law is an emerging field of public international law. It is quite a large study in itself, and it would take several lecture hours for doing an extensive study of international human rights law. And for that reason, there's a subject offered by Atmajaya for studying specifically human rights law. But before I start, I would just like to make some small disclaimer. So aside from being a faculty of the School of Law of St. Louis University, I work as a government lawyer for the Office of the Solicitor General of the Philippines. And there might be some things that that might be contrary to the official position of my government that I would say today. And I take full responsibility for it. It's not, today's lecture is going to be a purely academic discussion and certainly not the official position of the government of the Republic of the Philippines. So with that disclaimer, let me start with the basic question that everyone is faced, every person who is faced with studying human rights law should answer. What are human rights? And it's not an easy question to answer, because pretty much probably in every jurisdiction in the world, there is debate upon what is included in the concept of human rights. certainly in my own jurisdiction in the Philippines, there are issues today, issues now, saying that human rights only protect criminals, only protect terrorists, those kinds of sentiments. And probably in other jurisdictions in England, there's also a criticism of the Human Rights Act of their law, a criticism that it's really a criminal rights act. So there is disagreement, I think, in defining what are human rights. But to understand where the disagreement comes from, let's take a look at the background. Where does the study of human rights, where did it start? So the study of human rights could be traced probably more of a philosophical affair rather than a legal one at the beginning. And this would probably started at the time where there was a discussion of what are natural rights, what's the natural rights of people, what are the divine rights, what are human law, natural law, divine law. And that was set up by the philosopher St. Thomas Aquinas. So at around that period where there is a study or a discussion or a development of the concept of what is natural law, then attached to that and as a consequence of that, there the concept of natural rights was also attached to that. But also probably a consequence of defining what are natural rights, what are divine rights, are all is the consequence that this also became the justification for the establishment of monarchies. And this would go along the history. The discussion of human rights is always an interplay with the rights of the people versus the rights or the powers of the sovereign. So going back to the establishment of the monarchy, the monarchy based its rights, its power upon the concept of divine law, which is one of the categories that Aquinas differentiated in his philosophies. And with that divine law, with that divine power, the kings ruled absolutely. They ruled absolutely. There was judgment without trial. The innocent were either incarcerated or executed without trial and even without fault. And essentially, as what Lord Acton said, that absolute power corrupts absolutely. This is the point where there is a sort of disintegration of the rule of law and the rising of the rule of man. Certain philosophers were out to produce, to make a better idea for the society. And this is where Hobbes, John Locke, and Rousseau developed the concept of a social contract theory, how a better government can be established, one that is not ruled by absolute power. So they have varying models of the social contract theory, but essentially the premise is that individuals are rational, are free. They have this natural right of freedom. and they would give up these certain rights to join a political society and to form a government, which in turn, what the government will return to them is the promise of the rule of law. These concepts of the social contract theory is where the philosophies of liberalism was founded upon. So liberalism is essentially the principles of liberty and equality. It's the principle that all men are created equal and endowed with certain inalienable rights. So that is the concept of liberalism. And this concept of liberalism became the foundation upon which the United States was built, and and their constitution was also built upon such an idea. And we see a sort of development in this sense. Regarding the Bill of Rights, Thomas Jefferson said that a Bill of Rights is what the people are entitled to against every government. That statement produces certain consequences. One is that rights, there are certain rights that are inherent with the people themselves. It is not given to the people by the government or by anyone else. The people, individuals, human beings possess these rights. They are entitled to it because it is inherent in them. And second implication is that the role of the government is not really to give the people these rights, because the people own these rights themselves. The role of government is simply to recognize such rights and not to interfere or not to impair those rights. So that's the foundation of liberalism and inherent rights. And with the US Constitution, along with other significant documents that was produced throughout the history throughout Western history, like the French Declaration of Man or the English Magna Carta. These different constitutions were formulated in different points in time. And these constitutions, building upon the philosophies that they preceded, these constitutions paved the way from pulling the concept of rights, of freedoms and liberties, pulling that away from the arena of philosophy to the arena of law. So from being mere ideas, mere theories, mere concepts, these rights, freedoms, and liberties were turning into something that is justiciable and something that is enforceable under the law. So now another implication of this constitution is that these ideas were being developed domestically. So the US Constitution, of course, governs the United States. The Declaration of Man is a political statement in France, and the English Magna Carta is a political statement in the United Kingdom. So for now, these ideas were being developed domestically in different jurisdictions. So from mere philosophy, these rights, liberties and rights, we see that it's transforming to something philosophical, to something legal. We see that throughout the development of philosophy and the constitutions. But when did these rights and freedoms, these liberties, became a domestic concern to something that is the concern of the international community, or something that the international community universally is concerned of? When is that point in time? And the common consensus among authors of human rights law or people studying human rights law is that the establishment of the United Nations and subsequently the declaration of the Universal Declaration of Human Rights, the issuance of that document, that is the point in time where human rights officially became something that that the law encompasses as a subject of international and universal concern. Of course, this recognition of human rights as an international and as a universal concern did not happen overnight. As we saw, it happened through several centuries. But in fact, the modern concept of international human rights law as an international concern was really something that was born out of necessity, and it did not really develop organically the way we think it is. The biggest irony probably in the development of international human rights law is that the human rights that we enjoy today were born out of the horrors of World War I and World War II. How? So to better understand this, we take a look quickly at a quick definition of the concept of public international law. What is public international law? Of course, it's the branch of public law that regulates the relations of states. That's the main topic of public international law. And as a consequence of the limits of public international law, only states have legal personality under public international law as a general rule. So if we take a look at Article 38 of the International Court of Justice, all right, sources and the other articles forming the International Court of Justice, it is clear that only states have legal personality under public international law. Individual persons, human beings, are treated as objects of international law, and essentially meaning that they have no legal personality under public international law. So it is around this period of World War I and World War II, that human beings as individuals were starting to have legal recognition before public international law. So from being mere objects of public international law to proper subjects of international law. And the main reason for that is that the international community of states was gradually seeing the need for an international approach on the protection of individual persons in this background of warfare. So like international humanitarian law, the Hague Convention, the Geneva Conventions, these were all executed for the protection of individuals. So while, of course, the Geneva Convention, the parties to that are states, of course. It's a treaty, only states can be part of treaties. So even though the parties to it are states, the subject of the Geneva Conventions was actually the protection of individual persons, like the protection of the sick and wounded soldiers, or the protection of the prisoners of war, or protection of civilians, inhabitants in occupied territories. These were the provisions in the Geneva Conventions. And again, this is signaling a trend of bringing public international law to protect individual persons. At the end of World War I, the Treaty of Versailles was signed by the state parties to the World War I. This is the peace treaty that ended World War I, but also a consequence of that Treaty of Versailles is the establishment of what we call the League of Nations and the International Labor Organization. The provisions, the treaties and conventions that are the offshoot of the Treaty of Versailles would point to a similar trend of using international law for the protection of individual persons. So one is the protection of minorities. So a consequence of World War I is the redrawing of essentially the borders of Europe. And European parties to these treaties, to the minorities treaties, saw that these redrawing of the borders and creation of new borders, etc., there should be a protection to the minorities who will be affected by the redrawing of these borders, because they will be prone to mistreatment, because essentially they would be certain minorities were once part of one border, then they would be included in another one. So there was a potential for mistreatment of minorities, and these treaties were a signal of the multilateral efforts of protecting specific persons, specific groups at the international level. So in a way, these treaties would be a signal that the way a state treats its inhabitants was now a legitimate international concern. Because before that, the more traditional view in public international law is that how a state treats its inhabitants is not part of international law. So again, the Treaty of Versailles resulted to the creation of the International Labor Organization. And part of the League of Nations Covenant was explicitly the goal of fair and humane conditions of labor for men, women, and children. So again, this is signaling a trend towards the protection of certain individuals, in this case, men, women, and children. The protection of certain individuals with international law or in an international context. And lastly, the League of Nations set up commissions on slavery, and established some conventions like the 1926 Slavery Convention, and developed other conventions for the suppression of the traffic of persons. What does these developments mean? They are signals or attempts to protect human beings as an individual through international law. Again, this is something that's novel. This is something that's new, because the traditional view of public international law is that only states have legal personality before public international law. So this is something that is now emerging and developing. But it was not a perfect development. Again, for one, with regards to the minorities, it was limited to a certain number of people. So the protection was only limited to the minorities. For the workers, the protection was only for the protection of specific people, essentially the workers. And all of these grants of protection were not really given because of the recognition that of the inherent dignity of a human person. There was something a little bit more, there's a more selfish reasons, or the states have more selfish reasons for protecting these certain people. Like they were protecting the workers so that they would not support communism. So communism was emerging at the time, and they were trying to prevent the people from supporting that idea. And for the minorities, they were essentially trying to prevent conflict. So at this point in time, at the end of World War I, we do not yet have meaningful international rights or obligations which would protect human beings as human beings. We did not have yet meaningful international rights or obligations which would protect human beings as human beings. And this is not to say that there were no efforts to do so. There were many efforts within this period of trying to develop a universal instrument, and a universal instrument that the international community would adhere to. So Albert de la Padrelle, a professor in Paris, André Mandelstam, a professor in Russia, Anton Frangulis, these were all the proponents of trying to produce an international document which is universal in application, that would protect the human being as an individual. So there were efforts during that time, but it did not come to fruition, essentially. Then came World War II. Of course, the same horrors of war happened during World War II. People were dying, of course, people were being invaded, etc. People were fighting a war which they did not really know or understand why they are fighting that war. Essentially, they were exhausted from the fact that they just came from one war and they are now fighting another. And they have no reason, they have really had no reason to do so, to fight this war. So one writer, one of the developments in this World War II is that an author wrote this paper or this article in a newspaper and essentially appended another paragraph to another essay to that, and essentially the rights of man. Essentially, but this H.G. Wells was trying to give a good justification for fighting in the war. And these were included in his writings are discrimination, natural resources, health, paid employment, etc. These he was trying to build a justification or essentially motivate the people from for fighting the good fight. So that's one development in that area. But really, the turning point in World War II, with respect to winning the war and the concept of rights, is when Theodore Roosevelt, in his speech before the State of the Union, proposed a vision of a post-war world, propose a new world order, or propose what should the world look like after the war. And the four essential freedoms comes into play. He proposed that there are four essential freedoms: freedom of speech, freedom of worship, freedom of want, and freedom from fear. And these freedoms would result to the supremacy of human rights everywhere. This, I think, is the first time the word human rights was actually invoked in the context of the war, or at least that specific phrase of human rights. This is the point where it's now starting to be invoked as a specific phrase, human rights. This speech was monumental, and Winston Churchill and Theodore Roosevelt had a dialogue thereafter and produced this document called the Atlantic Charter. This Atlantic Charter was agreed upon by the states, and essentially we're now envisioning a post-war world where it is essential to defend life, liberty, independence, and religious freedom, and to preserve human rights and justice in their own lands. So that Atlantic Charter, something that was agreed upon by the states, formulated by Roosevelt and Winston Churchill, is now the bedrock upon which the United Nations was born. So the UN Charter would invoke specific provisions on human rights. In fact, the United Nations itself was built upon the idea that these peace-loving nations who are parties to the UN will promote human rights, will encourage the respect of human rights without distinction as to race, sex, language, or religion. They would rule with the principle of equal rights and self-determination of the peoples, and promote universal respect and observance of human rights. Now, what the UN Charter would tell us is that in 1945, with the establishment of the United Nations, this is really the point where the concept of human rights was no longer invoked in a political sense or in a philosophical sense, but rather human rights was proclaimed to be a matter, a subject of international concern. So the community of states, the states who were parties to the UN Charter, had that common consensus that there must be protection of human rights, there must be respect and observation of human rights. But noticeably in the UN Charter, you would find no provisions on what are these human rights, except that the UN Charter just mentions that the peace-loving states would respect human rights. But what are these human rights? They did not really define it in the UN Charter. They cannot find yet, during this time, a common consensus on what should be included in the concept of human rights as an international concern. But the UN Charter would tell us certain attributes of human rights. From the wordings, the provisions of the UN Charter, we can, it could be inferred that human rights are universal, are inherent, and equal. These attributes were expressly recognized in the UN Charter. What does that mean? Inherent means all human beings are born with these rights, and similar to what we discussed a little while ago. They are not conferred by any authority. All human beings possess these rights because of being human beings. For that reason alone, human rights are universal. Human rights apply to all humans, regardless of nationality, place of residence, sex, nationality, ethnic origin, color, religion, language, or any status. So the UN Charter would recognize specifically that attribute, that human rights are universal. And as a consequence, human rights are equal, that every human being has the same rights, has the same set of rights as any other. So at this point, we don't know specifically what are the human rights the international community is trying to protect. It's not really clear from at that point in time, at the creation of the UN Charter. But what we know is that the states, the international community, agreed that human rights are universal, inherent, and equal. So the consensus of the international community in establishing human rights is that because of the limited time in producing and signing the charter, the UN Charter, actually defining what human rights are will be delegated to a certain group. And it was decided that the ECOSOC, the Economic and Social Council, would establish thematic commissions and working groups, among which are the old Commission on Human Rights. They would establish working groups, and each working group were assigned a specific task. One working group should adopt a set of principles and catalog of human rights. So essentially, this working group will be the one who will enumerate what human rights the international community is trying to protect, respect, and observe. A second working group was created to create legally binding instruments for the protection of those human rights, and will differentiate it later on. And the third working group was tasked to create monitoring mechanisms and procedures in the protection and observation of these human rights. Going to this first working group, headed by the wife of the US President Theodore Roosevelt, so Eleanor Roosevelt. It was Eleanor Roosevelt who led that first working group and came up with this document called the UN Declaration of Human Rights. One thing we have to mention is that when the first working group was created, they were tasked to adopt a set of principles and catalog of human rights, as opposed to create a legally binding document. So the intention of the creation of the UN Declaration of Human Rights was never about enforcement. It was never about creating a legally binding document, but it was about enculturation. It was about deliberately framing these rights as a broad set of principles that the international community can look to and aspire for the people. So not really binding. In fact, that's why it's a UN declaration. A UN declaration is not binding upon the parties. A UN declaration is more of a soft law, more recommendatory rather than binding, as opposed to a treaty, which would act pretty much like a contract between states. Here, it was placed in a UN declaration, a soft law. So even though it's an aspiration, an inspiration, it is really something that was being demanded by the people at that time. So the inspiration is really what the people are demanding at that time. And the most important thing about the UN Declaration of Human Rights is that it is where the human rights the international community wants to protect is enumerated. It's specifically enumerated in the Universal Declaration of Human Rights. These enumerated rights are assumed to be the rights that all individuals are entitled to. They are entitled to that. These are inherent rights, presumably. What are these? These are, if you read through it, you can Google it right now. You would see different rights, like right to life, right to liberty and security, rights of the criminal, rights of equality, equal protection, rights against discrimination, right to work, right to favorable conditions of living, right to rest, right to education, freedom of expression, etc. The UN Declaration of Human Rights has now specifically laid out the concept of what are human rights in the context of international law. And along with that enumeration in the drafting of it, and considering the diverse situations of the states who are trying to formulate this Declaration of Rights, there were concerns among the states. For example, in South Africa, where the apartheid regime had just begun, they cannot agree to the concept of the right against racial discrimination, because the apartheid is essentially based upon that idea of racial discrimination. So they could not agree to those provisions of discriminations against race and ethnicity. Islamic countries, some Islamic countries like Saudi Arabia, did not agree to the concept of, or to the right of freedom of religion, the freedom to choose a religion and to leave a religion. So they had reservations on that idea. And some of the communist countries, or even some of the democratic countries, were afraid that this declaration of human rights would be an interference to their sovereignty. Of course, they have to part of an agreement of the state to a certain document, for example, would really involve a compromise upon one's sovereignty. So that is a concern to them. On the other hand, there were and specifically focusing on the provisions of the UDHR on the right to work, to live to good living conditions, to education. There were also concerns from some of the states regarding that. One is, what would be the role of the state in providing for such rights of the right to work, education, living conditions? The Western democracies, of course, were leaning towards a laissez-faire economy, right? A free economy. And they did not want the state to interfere with those kinds of rights of work, education, living conditions. Whereas the communist bloc wanted the state to be at the center of providing such rights because of the philosophies of communism, of course. There were also concerns on the ability of developing states. So if this document imposes upon obligations upon states to give good working conditions, to give education, to give free education, to give rest, to give good living conditions, would that be unfair to the states who are still developing? Because they do not have that ability to give that to their people. So that was a genuine concern to the developing states. And also, the richer countries were concerned that if these obligations, these positive obligations of giving food, work, living conditions were made in an international context, would that impose an obligation upon richer states to give to the poorer states? So those were some of the many concerns of the delegates producing, drafting this UN Declaration of Human Rights. For the civil and political rights, there was not much compromise. There was not much compromise in this in these areas of anti-racial discrimination, freedom of religion, and that sovereignty. That's why some of the countries abstained from signing this document. But with respect to the social, economic, and cultural rights aspect of the UDHR, they developed a compromise, which we will meet again when we discuss a little bit about the treaty implementing this. So the compromise was for the positive obligations, for obligations of the state to give something, like to provide something to the people, like basic necessities of food, work, living conditions, rest, etc. The compromise is that this must be progressively realized. It is not an obligation that is instant upon the signing of this document. It's an obligation that should be progressively realized, so over time, and in accordance with the resources of each state. So that was the compromise formula in the UDHR. And with that, the UDHR would have provisions on both civil and political rights and economic and social and cultural rights. So let's go through some of them. We'll not go through everything, but just to see how the rights are enumerated in the UDHR. Okay, so the UDHR consists of 30 articles specifying guaranteed rights to the individual. Again, the premise is that these rights are inherent and guaranteed to the human, to each individual. So for the first two articles, we just set basic principles of that all human beings are born free, equal, and dignity of rights, the principle of equality of rights. And these rights shall have no, should be given without distinction of any kind. So that's just a basic principle that governs from the UN Charter up until now. But the actual enumeration of rights would start at Article 3. Article 3 is sometimes called the first cornerstone of the UDHR. So the literal concept of the cornerstone is that it's the first stone on which a building will be built upon, right? So in this sense, in the UDHR, Article 3 as the first cornerstone is the article which the ICCPR is essentially built upon. The Article 3 and the subsequent provisions are the provisions on civil and political rights. So right to life, right against slavery, right against torture, right of legal recognition of civil personality, criminal rights. Those are some of the provisions of the UDHR. And one thing I want you to notice at this point is that the UDHR, how the UDHR is written almost in absolute terms. So everyone has the right to life, liberty, and security of person. There are no attached conditions. There are no added stipulations. So almost in absolute terms. And that point will be important if we compare it later on with the ICCPR. Article 22 of the UDHR is sometimes called the second cornerstone. And because the Article 22 and the subsequent provisions would be the foundations upon which the ICESCR is formed. So these are rights to social security, right to work, free choice of employment, favorable conditions of work, right to standard of living, right to education. Again, the UDHR in these terms, in the social and economic aspect of the rights, are written almost, if not always, written in absolute terms. So the UDHR is an ideal. The UDHR are aspirations upon which the international community should strive. That was the basic principle of forming that document. But the goal is really to protect human rights within the context of something that is enforceable, that is binding upon the community of states. So after the UDHR was enacted or adopted by the UN General Assembly in 1948, they adopted a resolution that the UDHR should be implemented into two treaties corresponding to those separate categories of rights, of civil and political rights, and economic and social and cultural rights. The two treaties that would come forth from this is the ICCPR, the International Covenant for Civil and Political Rights, and the International Covenant on Economic, Social, and Cultural Rights. So these two treaties would essentially implement the first cornerstones, or the cornerstones of the UDHR. For the ICCPR, it would implement and safeguard rights, the rights to life, liberty, fair trial, freedom of movement, and so on, civil and political rights. And the ICESCR, International Covenant on Economic and Social and Cultural Rights, would implement the second cornerstone of education, work, food, favorable conditions of living, and the other cultural and social rights. It is said that the ICCPR are what we call the first generation of rights, and the ICEE, the rights involved in the ICESCR are the second or third generation of rights, depending on who the author you're reading is. So this two treaties, the idea of implementing the UDHR into two treaties, the ICCPR and ICESCR, and further down the line, further down in history, naming these rights as first generation or second, third generation. Does that mean, or is it the intention to place these rights in a hierarchy where civil and political rights are said to be more important than social, cultural, or economic rights? So that was never the intention of dividing the UDHR into two. One of the principles that the drafters of the UDHR and the treaties were working on is that human rights are interdependent, indivisible, and interrelated. What does that mean? It means that whether you're talking about civil and political rights or economic and social and cultural rights or collective rights, these rights are or one set of rights is not more important than the other. It is indivisible, interdependent, interrelated, meaning that to fully enjoy one set of rights, you need the other set of rights needs also to be developed. So you cannot develop one set of rights alone and expect and neglect the other set of rights and expect the full dignity of the human person. It doesn't really work that way. And to emphasize the idea, let me share two quotes from one quote from a prominent human rights lawyer in the Philippines, Jose Jokno, or was a prominent human rights lawyer. So, true, a hungry man does not have a freedom of choice, but equally true, when a well-fed man does not have a freedom of choice, he cannot protect himself against going hungry. I think it's a beautiful quote. And also related to that, men who are hungry are the stuff of which dictatorships are made. Both quotes would emphasize that for a person to fully enjoy the abstract concept of liberty and freedom, his physical needs would also have to be met. And that's why these rights, whether it's civil or political or economic, social, and cultural, they cannot be taken separately. They cannot be addressed separately. They are one and the same rights, leading to the human dignity of persons. So going back, if these rights if the two sets of rights, the civil and political rights and the economic and social cultural rights.
Excuse me, Professor Avila. Would you please cut your explanation short because of the time? So we would like to give audience questions or comments. So if you yes, maybe just 1-2 minutes if you.
Okay.
Okay.
So let me just try to finish through my slides. Why are there two treaties? Why is there an ICCPR implementing the political rights, and why is the ICSR implementing the economic, cultural, and social rights? So while there is a recognition that these rights were interdependent, indivisible, these two categories were different enough to warrant separate treatments. So they have to be implemented through different legal techniques. And of course, we have to consider that this is now a treaty. The ICCPR and the ICSCR is now a treaty. It is no longer a lofty aspirational document like a UN declaration. Once parties would sign this, it will be binding upon them. So that's the main reason for separating these two documents. And to highlight the difference, and how it is addressed, we analyze how civil and political rights work and economic and social and cultural rights work. So civil and political rights are often called negative rights, or that's how they are written in the documents of that in the ICCPR and the UDHR. It imposes upon a state to abstain from doing something. That's why it's a negative right. Whereas the economic, social, and cultural rights, it imposes upon the state it imposes an obligation upon the state to do something, to provide for something. Again, like work, food, education, favorable conditions of living. And thus, being negative rights, being rights that, being just obligations that would prevent a state from doing something, they can immediately be implemented and they could be cheaply implemented. Whereas economic and social cultural rights can only be progressively realized, considering the resources of the state and all of those. Again, civil and political rights does not depend on the resources of the state. It's just an obligation for the state not to do something and does not require budgetary measures. So it could be cheaply and immediately implemented. And the economic, social, and cultural rights are different. It depends on the resources of the state, requires budgetary measures, etc. And lastly, the drafters of the document sought that a creation of a monitoring body is a practical approach to monitoring if the states are compliant with the ICCPR. And they also saw that putting in this phrase in the ICCPR, to guarantee access to effective remedies. That's a practical expectation upon the states who are signing it. Whereas in economic, social, cultural rights, because of the nature of the obligations upon the states, it's not really, these solutions in the treaties were not really practical. So just again, going through the provisions on the ICCPR, some of the provisions, will not go through everything. What one can notice is that the ICCPR is implementing the UDHR. So the UDHR has shorter provisions, right? And it has shorter provisions. And as we said before, they were often worded unconditionally. Whereas in the ICCPR, it's a more detailed explanation of what those rights are. And one of the consequences to that is that in the ICCPR recognizes that these rights do not exist in the vacuum of international law. These rights exist in the domestic context, and the role of the domestic law really plays a big part on defining the actual details of attaining these rights. So the UDHR, again, aspirations, would present these rights as inherent and essentially unconditional. So like Article 20, everyone has the right to freedom of peaceful assembly and association, period. But the ICCPR, being more detailed and implementing really that article, would provide limitations to that right. Limitations that is legally recognized. So while everyone has the right to freedom of peaceful assembly and association, it could be limited by law or in the interest of national security and public safety. So that's a stark difference of how rights are written between the UDHR and the ICCPR. But the ICCPR would also recognize that there are rights that cannot be derogated whatsoever. They cannot be impaired whatsoever in whatever circumstances. And this is this is provided by Article 4, where derogation of rights are allowed, but in no case should the right to life be derogated. The freedom from torture, freedom from slavery, imprisonment from non-payment of debt, imprisonment for a crime that is not defined to be a crime, the right to be recognized, and the freedom of thought, conscience, and religion. Even in emergencies, these rights can never be derogated. The ICESR would act similarly. So these provisions in the ICESCR are the implementations of the second cornerstone of the UDHR. So while the UDHR would present the right to work, right to living conditions, working conditions, generally, the ICESCR would provide the detailed legal requirements for such rights. But again, emphasizing on the fact that these rights in the ICESCR is dependent upon the resources of the state. And the obligation upon the state is to achieve it progressively, not instantaneously. Just to emphasize that fact, even provisions of the ICESCR would insert that progressive realization of rights. Just to emphasize that these rights are not instantaneous. They should be progressively realized based on the resources of the state. So with that, with those three documents, the UDHR, ICCPR, and ICESCR, we now have what we call the International Bill of Rights. So whenever it's asked, what are the International Bill of Rights? What is the International Bill of Rights? It's these three documents, the UDHR, the ICCPR, and the ICESCR. For the ICCPR and ICESCR, they are legally binding documents. Being treaties, the parties who sign them are bound by the provisions within those treaties. The question is if the UDHR is also a legally binding document. And even though we said that it was only a UN resolution or a soft law at the time it was executed, today, the consensus among the states is that it is also a legally binding document. And what is the source of these documents? What is the source of the binding nature of the UDHR? For one, several constitutions have already included the aspirations, the provisions of the declaration in their own constitutions and in their own judgments. And in the international context, in international jurisprudence, there is an acknowledgement that the human rights obligations imposed by the UDHR is now beyond question. And in one doctrinal case in our jurisdiction, the Philippines, Government of Hong Kong versus Olalia, it's an extradition case. So in the Philippines, there is no or there is no explicit right to bail for a person who is detained due to extradition. So there is no law regarding that. The question came before our Supreme Court is that whether a person can post bail even in the absence of the law. And the Supreme Court our Supreme Court ruled that the aspirations in the Universal Declaration of Human Rights, the value of freedom, was already recognized by the international community as an international customary law. And with that as basis, the court said that there was no reason for them to deny the prayer of the petitioner of granting him bail, despite the absence of positive law to that effect. So, what are human rights? And this is the first question we posted in our discussion, and we really haven't answered it yet. But strictly in an international law context, in the study of international human rights law, human rights are the rights enumerated in the International Bill of Rights. So the UDHR, the ICCPR, and the ICSCR, internationally and legally speaking. Human rights are also the rights recognized by international law through treaties. So there are the 9 core treaties and international customary law and general principles of law. And of course, international law recognizes that this subject, international human rights law, does not exist in the vacuum of international law. So human rights are also that considered by the national law as human rights. But I think beyond that, beyond legally speaking, beyond strictly legalese and legally speaking, the law should mean something, right? And human rights should not be limited to this legal sense, of course, in our everyday lives. Human rights should always start in our smallest community. The recognition of it, the observance of it, and the protection of it should always start in the smallest community and not in the strictest legal sense that we've talked about here. So I'm going to end my lecture there. To give time for...
Yes, you end your presentations, Professor Avila, right? Okay, so we still have time, even though it's limited time, but at least there is a chance for audience to ask or raise questions or to give comments or share something. Yes, and I would like to ask you, Professor first, to take 1-2 minutes to use Indonesian language just to give a very, very brief, translation, just to trigger audience to raise questions. Professor Avila, is that okay? Right? Okay. Ya, jadi kuliah ini itu sebenarnya tadi diawali dengan pertanyaan apa itu HAM, lalu ceritanya panjang karena bisa beda-beda. Intinya bahwa awalnya pembicaraan soal HAM itu, diskusi soal HAM itu lebih terkait dengan aspek filosofis, bukan hukum, sehingga ya lebih ke konsep-konsep tadi. Jadi di situ panjang lebar tadi disampaikan ya macam-macam, ada natural law, berarti juga ada natural rights. Lalu berarti kalau nanti negara dipimpin oleh satu monarki ya bisa saja, lalu itu akan memunculkan ya kekuasaan yang absolut. Tadi ada macam-macam disampaikan pendapatnya Lord Acton, lalu kemudian muncul pemikiran untuk rule of law untuk membatasi itu semua. Jadi awalnya itu, sehingga kemudian pertanyaannya itu atau kelanjutannya adalah sesuatu yang sifatnya filosofi itu kemudian berkembang menjadi yang law. Sesuatu yang berawal dari idea, teori, itu menjadi sesuatu yang bisa di-enforce oleh hukum. Gitu. Nah, sehingga kemudian akhirnya diceritakan tadi macam-macam, lalu negara-negara mengembangkan apa itu HAM di masing-masing negaranya. Tapi kemudian juga dalam perkembangannya pemahaman yang di tingkat domestik itu kemudian juga berkembang di tingkat masyarakat internasional, sehingga kemudian dipaparkan tentu kalau awalnya dari Perang Dunia Pertama, Perang Dunia Kedua ada banyak persoalan, sehingga muncullah ide-ide untuk melindungi pihak-pihak individu tadi, lalu kemudian muncullah piagam PBB. Di situ sudah mulai disinggung soal HAM ini tadi, dan itu bisa dikatakan sebagai global concern, perhatian dunia. Jadi itu, lalu kalau tadi juga disinggung sedikit soal ada dua istilah, hukum humanitarian internasional dan international human rights, itu beda. Kalau yang humanitarian tadi untuk perlindungan warga yang luka, yang perang, tapi kalau human rights itu dimanapun, kapanpun, baik perang maupun tidak perang itu berlaku. Kalau humanitarian itu lebih terbatas tadi. Nah, kemudian bagaimana ini kemudian berkembang, lalu macam-macam nanti urutannya. Tadi diceritakan kapan sih mulainya di level internasional itu muncul pengakuan, penghargaan, penghormatan pada HAM itu tadi kan. Beberapa tadi ada Treaty of Versailles, kemudian ada Atlantic Charter dan seterusnya, itu mulai dicari sejak kapan sih itu ada pengakuan itu. Tapi lalu kalau kemudian diurutkan, akhirnya narasumber ini tadi Profesor Avila itu lalu memaparkan ya berangkat dari UN Charter, piagam PBB ya. Jadi piagam PBB itu sudah mulai menegaskan ini sudah konsep HAM yang tidak lagi dalam konteks politik ataupun filosofi gitu. Nah, sehingga kemudian dijelaskan dan paketnya itu nanti kan muncul international covenant itu yang ICCPR yang civil dan political rights, yang satunya ekonomi, sosial, cultural. Nah, itu yang sudah mulai kelihatan jelas, sehingga lalu dipaparkan tadi. Dan bedanya dari kedua itu, kalau yang civil politik itu bisa langsung ya, kalau yang ekonomi, sosial, ekonomi, kultural itu ya harus bertahap. Nah, negara-negara sikapnya kalau yang terhadap yang civil politik itu tadi ada soal apartheid, freedom of religion, ada sovereignty. Jadi negara khawatir kalau itu nanti itu jalan yang di Universal Declaration of Human Rights itu akan menimbulkan Afrika Selatan akan ini nabrak apartheid negara Arab tadi. Kalau freedom of religion ini jadi agak berbeda. Kemudian negara komunis itu soal sovereignty-nya agak terganggu kalau diutak-utik. Itu kalau yang social economic itu tadi memang konteksnya lebih progresif, jadi tidak harus serta-merta itu bisa jalan begitu ya, tapi harus bertahap sesuai dengan keberadaan resources dan semacamnya. Jadi ada UN Charter, ada Universal Declaration of Human Rights, lalu ada dua yang ya sebenarnya sudah dipelajari, yang International Covenant mengenai hak sipil politik itu, dan satunya Economic, Social, Cultural itu tadi. Dan dua itu bukan hierarki, tapi tadi dikatakan yaitu saling melengkapi meskipun ada ini generasi satu, yang satunya generasi dua, tetapi itu bukan satu urutan bahwa yang satu lebih penting daripada yang lain. Jadi itu beberapa yang sangat ringkas hanya untuk membantu mungkin sedikit mengaitkan apa yang disampaikan oleh Profesor Avila di dalam ceramah ini. Nanti silakan untuk masih ada waktu pertanyaan, cuma sedikit tambahan bahwa beliau ini prinsipnya adalah lawyer, solicitor. Beliau mengajar part-time di St. Louis University. Dia lulusan JD, Juris Doctor. Juris Doctor itu setelah SMA pasti harus ada studi dulu, itu tadi kan bachelor, lalu JD. Kalau di Indonesia itu setelah SMA langsung fakultas hukum, jadi agak ada perbedaan. Jadi itu mengenai beliau tadi ya. Now it's time for audience to raise questions or comments to Professor Avila. Yes, on the screen, chats. Is there any questions? Or before? Okay.
Yes, there are two questions, Mr. Endro. There are three questions from the person. Let me read the question, Mr. Endro.
Would you please? Yes, the questions. Okay, it's too small. Yeah.
From Indra from Faculty of Law Atmajaya Yogyakarta. My name is Indra Limas. I would like to ask a question. Free speech has been the most argued human right. I believe among many human rights, as we know under international law, I think it's too long question, Mr. Endro, or maybe we can ask Indra to raise hand and to ask him directly.
Yes. Would you please raise your hands and please say your questions directly? Okay.
Indra?
Yes, go on.
All right. Thank you. So my question actually will be, one is that as we know, under international law, free speech may be permissible, may be subject to the limitation under Article 90, Paragraph 3 of ICCPR. And there are also principles of necessity and proportionality in order to enforce limitations to free speech. And in the General Comment number 34, in the paragraph 35, states that there must be a direct causal link between the expression and the harm that would be caused by the exercise of the right in order to satisfy the principle of necessity and proportionality. So my questions are, shouldn't we also consider the imminent threat or harm as the result of the exercise of free speech? And the second question will be, if yes, what is the standard of this imminent threat, especially under international human rights law? Thank you.
Yes, Professor Avila, you may just directly answer to these questions, please.
Okay, thank you, Indra, for raising that. And I will try my best to answer it based on what I know. So the ICCPR and the general comments 34 and 35, I believe both were written in a way that the states would have some flexibility to how will it be enforced within their jurisdiction. And in that sense, in the context of free speech, what would be the standard for limiting free speech? And I believe it would be a different standard between different jurisdictions. In our jurisdiction in the Philippines, we follow the New York Standard Times test. In the case of the New York Times in the US, a 1940s US case, the standard we follow is that the limit on free speech is actual malice. So whether a person is liable, criminally liable for defaming a person, it is dependent upon the intent of the person. If there is actual malice, in the sense that if there is no actual malice, then he is not liable for the speech that he gave, even though it defamed a person. So I hope that answers the first one. That yes, the threat or harm as a result of free speech will always be there. But the standard would be, if you will be criminally liable, then that speech must be done with actual malice. And if it's not, then you are not liable for the speech you gave, even though it caused harm to another person. I don't know if the standard is the same for your jurisdiction, but the actual malice in our jurisprudence is defined to be either an intentional, a place of intent where you really intended to defame a person, or actual malice would also involve a reckless disregard for the truth. So in that sense, no, even if you did not actually intend the malice when you defamed the person, but there was a reckless disregard for the truth, for the thing that you said, then you are still criminally liable. So that is the standard in our jurisdiction for actual malice. And I think what is the standard of international human rights law? I think it would depend upon the jurisdiction on which the actual case is being heard.
Yes, that's the first question, and it has been answered by Professor Avila. We still have the second questions.
There are three questions more from Rabin and Ricardo. Would you please, Rabin and Ricardo, to ask your question directly, please?
Okay. Hello, Prof. It's Rabin. I want to already has a human rights court located in Strasbourg, which oversees the implementation of protection of human rights by the European states. In your opinion, does ASEAN need a court or arbitration body on human rights?
Yes,
I think there is an effort to build similar to the ASEAN Vision 2020. I think part of that is that the ASEAN intends to build an ASEAN human rights court similar to the European, African, and American models. But I think the main hindrance to this is cultural relativism. So although human rights ideally are universal, there is debate upon, even in the ASEAN community, if these rights are actually universal in the sense of how the UN dictated it. Ideally, there are several schools of thought, I think, that the advocates for human rights would not make the cultural relativism an excuse for the effect of the universality of human rights. But since actually making a court of human rights would involve a complicated legal and political would make complicated and political and legal implications. I think this is far from happening, but I know that there are some people who are working towards building a ASEAN court, ASEAN human rights court.
Yes. Next, Mr. Ricardo, please. Would you say your questions directly? Raise your questions to Professor Avila.
Thank you for the time, sir. Hello, Professor. I would like to know your views on human rights in international law based on Article 3, 5, and 6 UDHR. First question, what do you think about the death penalty? Is the death penalty relevant and permissible in certain cases? My second question will be, what do you think about the case of arrest and interrogation of prisoners who violate human rights? Are human rights violated by the police or the cop justified to obtain information?
Okay, so first question, the death penalty. The ICCPR, the UDHR and the ICCPR does not in itself prevent the death penalty. But there is the second optional protocol of the ICCPR. So there are two optional protocols for the ICCPR. The main text, the ICCPR, first optional protocol would be the establishment of the Human Rights Committee and the complaints procedure. So essentially that allows for the individual filing of a communication. And the second optional protocol is for the states who signed the second optional protocol. They are bound to prohibit the death penalty from being imposed in their own jurisdictions. So in a strictly legal sense, in a strictly international law legal sense, the death penalty is permissible. The documents do not prohibit that. However, if the state is a party to the second optional protocol, which binds the state to prohibit the imposition of the death penalty within their jurisdiction, then it becomes a violation if they would impose the death penalty even though they are signatory to it. In a strictly legal sense, it's in a political sense, it's very much up to debate, right? There are so many discussions on the death penalty. For the second question is essentially, is torture allowed? Am I right if I'm trying to summarize the question? Can torture be justified to get information? So this is where the UDHR and the ICCPR is clear. No? Under no circumstances, torture in cruel treatment, in cruel treatment, etc., in cruel punishment should be allowed. It can never be allowed under the ICCPR and UDHR. This is what we call a non-derogable right. And even in times of emergency, the ICCPR is clear that the torture can never be justified. So it will never be justified in peacetime, obtaining information, and it will never be justified in times of emergency.
Yes, that's the answer or response to the questions raised by the last member of the audience. Ibu Sekar, is there any? Do we still have time for raising questions, or should we end?
I think the last one from Amalia Maharani.
Yes, yes,
Mr.
please.
Endro, yes.
Please say your questions directly to Professor Avila.
Yes, hello, good afternoon. So, as you've explained earlier, in international, there is a generally set standard of how human rights should be implemented. However, in the reality, domestic laws does seem to prevail. Now, with the dynamic nature of things, like perhaps even with the existing conventions, there should be some changes or amendments made to situate ourselves with what changes has been occurring in the world. How do you think the states that have progressed rather slowly be able to incorporate such laws quicker? Thank you.
Okay, so I think that could be answered by the political situation of the country, right? It's these are laws are essentially a product of policy, and whoever are in the position of power would dictate how to move forward with um, with the treatment of human rights in their jurisdiction. But one thing of note in your question is that you said that domestic law would seem to prevail. So public international law would set some standards on how to resolve conflicts between international law and domestic law, right? Like the Fitzmaurice Compromise. So I don't think it's always true that domestic law prevails always, because it would always depend on where the case is filed, who is hearing the court, and what are the laws that that's in conflict during the litigation of that case. So that is properly answered by public international law and not necessarily international human rights law.
Okay, thank you for Professor Avila for answering, the whole question raised by audiences or students joining this lecture. Well, it's about the time, just the time we have to stop, we have to end our lecture given by Professor Avila. And I would like to thank to Professor Avila for delivering, for sharing your insights, your experience to the audience. Hopefully it will be providing a trigger to explore, more about international law and human rights, and I hope that will be a very interesting subject to explore more. Again, I say thank you, and also thanks for the audience for joining this lecture and raising questions. Or something like, and we see again next opportunity. Thank you. And time is yours, Ibu Sekar.
Well, thank you for Mr. F.X. Endro Susilo was leading us in our virtual lecturing today. And also thank you very much for Mr. Eti Anton Luis Avila as the speaker for informative and insightful presentation. Let me remind all the participants, please fill the attendance link form that I have attached in chat column. So every year, International Human Rights Day is celebrated, and now Faculty of Law, Universitas Atmajaya Yogyakarta is standing up for human rights. I would leave you with a quote by Nelson Mandela. To deny people their human rights is to challenge their very humanity. I am Sekar Chandra on behalf of organizing committee, extending our appreciation to each and every one of you for attending this agenda. Let us all be guided by all the things that we have learned and heard throughout this virtual lecturing today. See you again and thank you.
Thank you, Pak Endro, Prof. Avila. And don't forget, after this webinar, And then there is a webinar from Pasmani Peter Catholic University of Hungary.
Yes.
5 p.m. Thank you.
Thank you so much.
And the witness, MU Pak Hengki.
Prof. Avila, thank you very much.
Prof. Avila, Pak Endro.
Okay, greeting to St. Louis
All of
University.
the audience, thank you very much. Good afternoon.
Good afternoon all.
Good afternoon.
Thank you.
Yes.
Thank you, Bu Sekar.
You're welcome, Pak Budi.
Thank